Well, ladies and gentlemen, obviously this podium was meant for another convention. In case you're wondering what I mean by that, the place upon which you can lie your papers is 3 feet below my knees, so I'm going to, you think I'm joking, I'm not. I'm honored to be invited to speak here, especially speaking with and in front of and about a subject that some of the men and women in this room have tutored me on for the past 30 years. And as the old expression goes, they have forgotten more about the Advise and Consent Clause and the constitutional issues that I'm going to speak to today than I know. They include Larry Tribe and Walter Dellinger and Chris Schrader and many others who have been stalwarts in trying to educate me over the years as to my responsibility. As a matter of fact, don't blame Larry Tribe for my being a constitutional law professor. When I was asked to do that right after the board hearings, I decided I would do it, and I was originally going to do it at Georgetown University. Deceased Father Healy had asked me whether I would do it, and I realized it would mean I had one more day to commute, and I didn't want to do that, and I've been doing it at Widener Law School. If you're wondering why there's been such an aberration in the lack of understanding of constitutional issues by young lawyers, I'm partially responsible. Look, I have a serious speech, and you are eating, and I'm a United States Senator. I'm very accustomed to not being paid attention to, so please continue to eat. What I have to say is going to take about 25 minutes, and I apologize for the length, but I don't know how to address as serious a subject, quite frankly, in a shorter fashion. I'd like to begin by reading two quite different quotes to you, each from important jurists. Jurist number one, and I quote, "Our laws and traditions afford constitutional protection to personal decisions relating to marriage, procreation, contraception, family relationships, child rearing, and education. These matters, involving the most intimate personal choices a person may make in a lifetime, choices central to personal dignity and autonomy, are central to the liberty protected by the 14th Amendment." The quote goes on, "At the heart of liberty is the right to define one's own conception of existence, of meaning, of the universe, and the mysteries of human life. Beliefs about these matters could not define the attributes of personhood were they formed under compulsion of the state." Jurist number two, "Compare the facts in Griswold with hypothetical suits by an electric utility company to void a smoke pollution ordinance as unconstitutional. The cases are identical. In Griswold, a husband and wife assert that they wish to have sexual relations without fear of unwanted children. The electrical company asserts that it wishes to produce electricity at a low cost. There is no principled way to decide that one form of gratification is more worthy than another." End of quote. Now, many of you, including Larry and Walter and others who helped me prepare for a hearing years ago, know exactly what law review article that came from. It will not surprise you to know that and I suspect most of you, agree with jurist number one. In my opinion, the first quote I read is a much healthier understanding of our Constitution with regard to the respect it affords individuals in making fundamental personal life choices. There are periods in our country's history when Americans re-examine the essence of the social contract. They've occurred a half a dozen times, this re-examination. These periods invariably include debate over the meaning of our civil Bible, the Constitution, because we have relied so much on that document to articulate how we see ourselves as a people and how we see ourselves as a nation. And let me say at the outset, honest people, bright people, decent and patriotic people have very, very different views on how to read our civil Bible. But such an examination that is occurring again today, that re-examination happened in the Civil War, it happened in the 30s, and it's happening again in our lifetime, having been going on in earnest since the mid-1980s. First, the debate over how much government should be able to intrude upon the most personal choices of Americans. This is Terri Schiavo and much more. The second, the other side of that same coin, is a debate about whether government can act as a shield to protect people from the abuses by powerful interests. For example, can we keep tobacco companies from targeting our children? The questions are debated daily. These very questions are debated daily in the House and the Senate. They're debated in the halls of academia. They're debated over the dinner table in homes throughout America. And just as in prior periods of our history, they are debated most vociferously when a vacancy occurs on the Supreme Court of the United States, the filling of that vacancy which has the potential to fundamentally alter the direction of the court. That's when the debate reaches a crescendo. And it has reached it today with good and just reason. The debates about a confirmation are one of the most important venues for raising fundamental questions about which constitutional view is better for our country. And the outcome of the debate can make a huge, huge, huge difference. The quotations which I began with express very different constitutional views. The second, will not surprise you, was written by Judge Robert Bork, who came before the Judiciary Committee in 1987 as a believer in a kind of strict construction. He was a self-proclaimed originalist. He had previously said, and I quote, "It is necessary to establish the proposition that the framers' intentions with respect to freedoms are the sole legitimate premise from which constitutional analysis may proceed." According to originalist logic, many Supreme Court decisions that are fundamental to the fabric of our country are simply wrong. By Judge Bork's own estimate, dozens upon dozens, including major decisions, holding that couples could not be prohibited from using contraceptives, rulings that the government could not involuntarily sterilize criminals, rulings relating to the incorporation doctrine, were all declared by Judge Bork and others who embrace what we now call the Constitution in exile, believe firmly to be constitutionally incorrectly decided. At that time, I particularly thought it critical to probe Judge Bork's views on privacy. Judge Bork stated quite clearly he believed there was no general right of privacy that the Constitution protects. Judge Bork would never have written, let alone joined, the opinion that contains the first quotation I read. Justice Kennedy, it's actually quotation, parts of a quotation from two cases. Justice Kennedy in the first instance, and joined by Justice Souter and O'Connor in a concurrence in the second. A man who took the seat for which Judge Bork had been nominated, authored the language that I quoted you first. His views reflect, in my judgment, a much healthier, and that's an unusual word to use in reference to the Constitution, but a much healthier view of the Constitution and its role in our society. When the Senate voted not to confirm Judge Bork, it sent a message that his views were not right for the country. And make no mistake, however, that did not end the debate. But also make no mistake that the defeat of Judge Bork did not have a profound effect on constitutional jurisprudence and the lives of average Americans the last 20-some years. Just place Bork every place where Kennedy has been in every decision. Nice little project for you 1Ls. And you'll see a very different America. Not an America outlined by bad guys, not an America outlined by people who are trying to feather the nest of any interest, but honorable, decent people who have a very different view of the Constitution and those ennobling phrases, which we're going to be debating 200 years from now. There's a lot of misdirection out there these days on these issues, where terms and phrases are used to mask what's really is at stake. The innocent-sounding but misleading term strict constructionist is used. Who can be opposed to a strict constructionist? Obviously, read the Constitution as it is intended. You know, Dooley, remember that old cartoon back in the turn of the last century? Dooley turned to his Irish buddy and said, the Constitution is a great document, you just need an interpreter to read it. Well, the terms and phrases used today, I think, mask what's at stake. The innocent-sounding and misleading term, strict construction, is used when what is really at stake is a wholesale liquidation of any constitutional protection of privacy. A wholesale liquidation, depending on if they use strict construction the way Bork meant it or the way Hugo Black meant it, depends on what they mean by the phrase, which means the phrase does not tell you much of anything. The American people are smart, though, and I believe that over the course of the upcoming weeks and months, they'll get it. They'll see to the heart of the matter about what really hangs in the balance. And if anything, the stakes haven't decreased since 1987. They've increased. I find it interesting. Ever I remind Larry and Walter, who helped me write a speech to the ABA right on the heels of when, in fact, the New York Times, the Washington Post, and the LA Times, if memory serves me, was about to endorse Mr. Bork, you recall. We went out and we decided to take the mask off. And the ABA was about to say, only things you can consider are whether or not the person is bright, honest, decent, has a judicial temperament. And we were probably the first ones to say in a generation, hey, it matters what they think. It matters what their constitutional method is. Seriously, you law students in there, go back and read law review articles prior to 1987. And you'll find virtually no direct reference, with the exception of a guy who I'll quote later, who will surprise you, that it is appropriate and necessary for us to look at the constitutional methodology because it makes a difference in our lives. The most immediate consequence of Judge O'Connor's leaving the bench, and by the way, as all of you know, since 95, there have been 193 5-4 decisions. Justice O'Connor was a majority in 148 of those 193 decisions. The most immediate consequence of Judge O'Connor's retiring may be that Justice Kennedy will replace Justice O'Connor as the swing vote on the Supreme Court. To be sure, Justice Kennedy is comparatively moderate on certain key issues. For instance, decisions stopping capital punishment of juveniles and the mentally retarded. But while Justice Kennedy is no Judge Bork, he is also no Justice O'Connor. For example, Justice Kennedy believes that any affirmative action in higher education or race consciousness in redistricting amounts to impermissible discrimination under the Constitution. He further thinks that most campaign finance reform laws are unconstitutional and that Congress cannot permit the disabled to sue states to force the states to make their courthouses accessible. And there are already cases on the Supreme Court docket for next term involving assisted suicide, the use of race as a factor in striking potential juries, the issue of federalism that would allow a new justice to begin rewriting our nation's constitutional law at the first juncture. The country will also be facing certain critical questions to the extent to which the President of the United States, any president, can exercise unchecked and thus unlimited power in national security matters at the expense of the rights of average citizens. Instances where Justice O'Connor would predictably have been a voice of moderation and reason, a voice respecting the Constitution's system of checks and balances. It was O'Connor, after all, who issued an important cautionary note to this administration when she said, and I quote, "The state of war is not a blank check for the president when it comes to the rights of our nation's citizens." But this is just the tip of the iceberg. While it is essential for Americans to understand how much hinges in the balance over the next few weeks, we also need to think in generational terms. We currently have justices serving on the Supreme Court nominated by President Nixon and Ford. We even have justices in the lower court still serving, appointed by Presidents Kennedy and Eisenhower. From the early 1800s, in fact, the average time federal judges spend on the bench has increased from 15 years to 24 years. God willing, in your case, Justice Sloviter, it will be 50 years. And I'm going to do something now that is somewhat imprudent. Will surprise you coming from me, I know. I'm going to make a prediction as to the most important issues the Supreme Court will face in the next 20 years or so. And the first is, to the extent that Americans' personal privacy, it relates to the extent to which Americans' personal privacy is honored. Like the Talmud, the right to be let alone under that fig tree, paraphrasing it. Is there such a right? And second, the ability of the American people to protect ourselves against powerful organizations, powerful interests, whether they be government or private, and large economic forces that run roughshod over us. For decades, the consensus has been that government should stay out of the bedroom, but be able to regulate the boardroom where necessary to protect vulnerable Americans. Yet the radical right is aggressively trying to upset that long-standing American consensus and reverse it. The first issue, whether government will be able to intrude in America's most personal life choices, took center stage in the '87 Supreme Court battle, and it is returning with a vengeance. This is Terri Schiavo and much more. Let me say point blank, notwithstanding the fact that constitutional scholars disagree and differ on this point, I believe the American people believe with every fiber in their being that the Constitution creates a zone of personal autonomy the government should not be able to intrude upon. And make no mistake about it, folks, the American people believe that. Larry, remember when we were doing Bork? Then we were sitting on my side screen porch preparing, and God love him, Professor Kerlin, one of the great constitutional scholars, known as a conservative constitutional scholar from the University of Chicago, was sitting there. And I said, and I turned to you with young Ron Clayton as my son, I said, we ought to make this about privacy, about Griswold. And he said, no. There's too much debate. And we were about to go have lunch at a place in the Greenville Shopping Center. I said, well, Professor Kerlin, I'm telling you what I believe the American people think. I said, please come with me and stand behind me, you guys, as people walk up to the shopping center and just listen to what people say. And I think I embarrassed him. I would ask the first 6 or 7 women and men, mostly women who came forward, I said, ma'am, I'd say, my name is Joe. Oh, yes, Senator Biden. Or, yes, Joe. I'd say, do you believe you have a right to engage in any consensual act in your bedroom with your husband? And I remember Kerlin turning red. I'm serious about this. Do you remember this? And I said, and they'd all said, everyone said yes. Or like, why do you ask? But yes. And then I'd ask them the following question. Why do you believe that? And every single person said, the Constitution. That's the phrase they used. They said, the Constitution. Now, I know to scholars and to all of you great lawyers, that is not necessarily relevant. But I'm telling you, it is incredibly relevant. Incredibly relevant. While many people, many people, smart, educated people, assume that the personal privacy protections in the Constitution are inviolable and will always be in existence, the constitutional exile crowd, they don't. It believes not just that privacy rights should be diminished, its members believe that there should be none. I repeat that. No general right of privacy whatsoever in the Constitution. So what does that mean, other than the academic debate we all engage in? Well, first, the government, whether state, federal, or local, could forbid couples, as they had in the past, from using contraception. The government could also constitutionally impose restrictions on the number of children you have. A bizarre notion exists in other countries, and God only knows what happens here in 2, 5, 10, 20, 30 years. This may seem an unlikely outcome, but remember, this is the same crew that brought you Shivo. Moreover, the next 20 years will be marked by great developments in medical and informational technology. Will individuals be able to take advantage of stem cell research with its enormous promise? Or will legislators enact their moral opposition? And will a conservative Supreme Court refuse to step in to protect those individual rights, acting as a shield? Will the government have unlimited power to monitor individuals, like I'm being monitored now? 10 minutes left on the Craig Amendment on the gun bill. I know how I vote on that. The amendment will pass whether you vote or not. Do you want to vote no? Yeah, I would vote no. Tell them I'm going to stay and finish this speech, okay? Well, will the government have unlimited power to monitor individuals, what they say, where they go, to whom they meet with, who they associate with? Will originalist judges tell us their historical investigations of the Constitution convince them the framers would have been comfortable with this kind of limitation? Will our justices protect our medical records, information regarding genetic propensities for diseases, financial data? This and more is at stake over privacy. It goes well beyond Roe v. Wade. And for as long as the radical right has been trying to reverse our constitutional understanding of privacy, they've also been trying to reverse a consensus that no one's talking much about except some of you in this room. A consensus going back to the days of the Great Depression, that government can act as a shield to protect Americans from the abuse of powerful interests. Can we protect the air we breathe? Can we keep arsenic out of our drinking water? Can we keep tobacco companies from targeting our kids? Can we establish minimum national standards to provide equal opportunity and human dignity for society's most vulnerable members, the elderly or disabled, women victimized by violence? Can we have a national consensus that is constitutionally protected on those issues? That is all at stake. There are instances when our democracy has stepped in to alleviate inequities. These are instances, I should say, when they've stepped in to alleviate inequities, to recognize human dignity, to lift people up by ensuring equal opportunity. Others, however, disagree with this consensus. Michael Grieve of the American Enterprise Institute puts it straightforwardly. One of the things, by the way, a lot of you, probably this is the wrong audience to say this to, because you probably don't fall in this category. A lot of people on my side of the aisle are so used to Democrats saying things they don't mean, they think these guys say what they don't mean. They mean what they say. They mean what they say. I'm serious. It's a very important point. They mean it. As absurd as it may sound, they mean it. Unless you doubt me, go on the American Enterprise Institute website. Read Michael Grieve. I'm sure he's a fine, bright guy. I mean that sincerely, not a joke. I wish he weren't. It'd make it easier. But here's what he says, how he puts it. He said, I think what is really needed here is a fundamental intellectual assault on the entire New Deal edifice. We want to withdraw judicial support for the entire modern welfare state. That's what this is about. This is not about a debate about the solvency of Social Security, for example. It's about the legitimacy of Social Security. This is not about a debate. Listen to the debates going on underneath these constitutional issues. It's about devolution of government. It's about withdrawing as a matter of law the right of the federal government to do much of anything other than provide the national defense. Unless you think they don't mean it, I'm the guy that wrote the crime bill. 100,000 cops, they vote against it, even though they love it. Not a joke. They love it. They can't say a negative thing about it. But they vote against it because, quote, it is contrary to the paradigm of devolution of government. The federal government should not be involved in aiding local government. That's the legislative way they're trying to change the court judicially. This is the agenda, folks, and the court already has such acolytes. Justice Thomas has voted to strike down over 65% of the federal laws that have been reviewed by the court. What would happen if we had 5 Justice Thomases? Not, just seriously, think about it. Think about it. This president will be president for, God willing, 3 more years. Look at the actuarial tables. Again, I don't mean this to be humorous. I am deadly earnest about this. 5 Thomases, thousands of laws, environmental, criminal, civil rights, could be declared unconstitutional. Justice Thomas wrote in one of his opinions recently, quote, "If anything, the wrong turn was the court's dramatic departure in the 1930s." End of quote. What I've described as a healthy consensus, Judge Thomas and others call a wrong turn. What's at risk if this view of the Constitution ever gained full ascendancy? The Clean Air Act, the Safe Drinking Water Act, the Clean Water Act, the Endangered Species Act. They all rely on the commerce power. I'll not review with you what Larry and others have taught me, but there's been a fundamental change in jurisprudence relating to the Commerce Clause already. The radical right is determined to elevate private property at the expense of protecting our safety, well-being in our communities, and under their reading of the appropriate language in the Constitution that is in question, from the Takings Clause of the Fifth Amendment on, the only way to keep a chemical plant out of your neighborhood would be to pay off the chemical plant to not build because you're taking their property. Our bedrock civil rights laws are also based on post-37 constitutional interpretations. There also could be no federal minimum wage, no maximum hour laws. We wouldn't be having a debate about increasing the minimum wage because there wouldn't be one. Lest you think this is hyperbole, look at what the debates taking place in local elections are about. Look at the debates that are taking place in the chamber in which I work. A slight digression, because I shouldn't, because it adds time. I said to 4 of my new colleagues, we were having a coffee and donuts before going into a committee meeting. I was joking. I said, I have a great idea how to deal with the plight of the elderly. And they all looked and said, oh, what you got in mind? It's a true story. I won't name the 4 senators. And I said, you know, we should pass a law mandating that every employer has to take 6 or 7% of the revenues and put it into a fund, and mandate that every single American, no matter where they work, has to take a similar amount and put into a fund. One of the new senators, I swear to God, said, that's confiscatory. One of the brighter ones said, you're not getting me to go there, Joe. But I'm not. Let me ask you this rhetorical question. Honest to God, take off your centrist or moderate or liberal, wherever you fall on the spectrum, hat. Do you believe if we did not have a Social Security law now, do you believe one could be passed today in the House of Representatives? Honest to God, what do you think? I don't think there's any possibility. And that, again, is, use the word twice, that's not hyperbole. So this is what's at stake, folks. This is the proportion of the potential consequences of the turning of the court. Under something called the non-delegation doctrine, the court may have to strike down the Occupational Health and Safety Administration, which is tasked to make sure American workers are safe. The problem under the non-delegation doctrine is that many of today's modern federal agencies are just like OSHA, in that they exercise broad rulemaking powers and enforcement powers that is unconstitutional according to many. Just go back, you 1Ls and 2Ls. Read an old case. Read Scalia's dissent in Mistrada. What would the world look like were it the majority view and applied beyond the special prosecutor? This is a doctrine, the non-delegation doctrine, that wisely gave way a long time ago to the reality of our complex modern age. Congress simply can't legislate every particular rule in detail, so it empowers agencies to do so, with Congress retaining the power to come in and oversee what that agency is doing. This system makes sense. It has some abuses that can be corrected through the legislative process, but it's at the very heart of what allows our government to function in this complicated society we live in. And it's not only OSHA that's at risk if the non-delegation doctrine and other doctrines favored by the constitutional exiled crowd, such as the requirement that agency members must be removable by the president at will, are accepted by the Supreme Court. The Federal Communications Commission, the Federal Reserve Board, the Securities and Exchange Commission, just to name a few, would hang in the balance. And there would result in a fundamental shift in power to the powerful, who we are attempting. We would go from the powerful to the extremely powerful. So what's the common theme here? It is to prevent, in my view, we the people, from being able to protect ourselves from the abuse at the hands of societies already powerful and growing more powerful. The radical rights agenda would give enormous power to the already powerful and eliminate the ability of the less powerful to use the democratic branches of the government to rebalance the playing field. But why are the courts so important to the radical right? And they are. In 1988, a Reagan Justice Department document stated, quote, "There are a few factors that are more critical to determining the course of the nation and yet are more often overlooked than the values and philosophies of the men and women who populate the third co-equal branch of the government, the federal judiciary." If there was ever anything the Reagan administration wrote that was accurate, that is it. The American Enterprise Institute's Michael Grieve recently stated, to quote him again, "I think the judicial appointments are what matter most of all, and I promise you that's what the right in the political spectrum understand as well." So why does the radical right, why don't they just push their agenda through the Congress and the state legislatures? First, the people don't agree with it. And secondly, it's an acknowledgement that their current control of Congress and the presidency is temporary, and now is the time for the right to strike and lock in their philosophy to handcuff future Congresses in being able to counteract the right's agenda. For once it is declared constitutional or unconstitutional, other than an amendment, we find ourselves at an overwhelming disadvantage to move through with the legitimate will of the American people. It is also an acknowledgement that the radical right can't take on the popular programs and policies in the clear light of day, or environmental and worker protections in the open. In the democratic elected branches of the government, they do not want to have these debates, so they focus their fire on the judiciary. Again, don't take my word for it. Richard Epstein, one of the intellectual powerhouses of this movement, said, quote, "Some movement in the direction of judicial activism is clearly indicated." I don't know where the hell he's been the last 20 years. It's already up and galloping. This is the most activist Supreme Court in our history, in my view. Struck down more national pieces of legislation than any court in American history. We're talking about a movement that would wield the Constitution not as a shield but as a sword, and to push an extreme, and I believe, agenda the American people do not support. And it's something that has already begun. The Rehnquist Court has been, as I said, the most activist in history, striking down a record 36 acts of Congress in less than 20 years. What kinds of laws is our High Court striking down? popular common sense laws. Laws that said, for example, you can't have guns within 1,000 feet of an elementary school. Laws battling violence against women. Laws requiring cleanup of low-level nuclear waste. And laws saying states can't steal somebody's ideas and inventions. Over the first 7 decades of the court's existence, only 2 federal laws were held TWO, held unconstitutional. Let me focus for a minute on one of those laws already struck down, one that's very near and dear to my heart. I grew up in a family where the worst form of unmanly cowardice that one could engage in was to strike a woman. It was the lowest act of all. And as a result, I wrote a law called the Violence Against Women Act. And I know people say I wrote that law. Not a joke. And no one liked it, as Walter will tell you. The women's groups didn't support it at the outset because they're worried it would trump choice and gender issues. I've never put so much energy into any single piece of legislation in my 32 years in the United States Senate. But I thought the single most important aspect of it was to empower women to take control of their own lives, to be able to go into federal court and sue their abuser for their watch, their car, their business, and their worldly goods for the abuse inflicted upon them, whether or not the state or federal prosecutor wished to proceed criminally. But in 2000, the Supreme Court struck down this right. Despite 9 hearings, over 100 witnesses, despite the support of 38 states' attorneys general, despite the overwhelming evidence of gender discrimination in local and state criminal justice systems. I term this, I realize that one man's meat's another man's poison, but I term this judicial activism. Laws like this are what is at stake in my view. We do well to recall the brilliance of the Founding Fathers who devised the system of judicial appointments specifically aimed at preventing the president from effecting a radical shift in the judiciary. When I was sworn in the Senate, I vowed to support and defend this carefully balanced system, and I have no intention of abdicating that responsibility. The question most asked of me by my students in the constitutional law course I've been teaching the last 15, 16 years, or however many, a long time, is what the founders intended the advice and consent clause to mean. To me, the answer is clear and overwhelming. The founders intended the Senate to take the broadest view of its advice and consent responsibility, and throughout history, the Senate has taken this responsibility to restrain the president very seriously. Over and over, the Senate has scrutinized nominees, constitutional methodology, and philosophy, and rejected nominees on that basis. 1 out of 5 nominees have been rejected over our history. And I, for one, find it useful to recall the 1959 statement by a Harvard Law record of a young Arizona lawyer named William Rehnquist. He called for the Senate, in writing for the Nixon administration, called for the Senate. Actually, he wrote it before he was with the administration. He called for the Senate, quote, for an approach of thoroughly informing itself on the judicial philosophy of a Supreme Court nominee before voting to confirm him, end of quote. This is particularly so, and always has been throughout our history, as Walter has taught me, and along with my good friend who I impose on much too much, Chris Schrader at Duke. The country has done this particularly when it's deeply divided and when the balance of the court is at stake. Think of how the world has changed since Justice O'Connor first joined the High Court. In 1980, almost none of us had computers. Emails were largely a figment of the imagination. The internet was a narrow path being blazed on the frontier of technology, not the information superhighway. Imagine what our world will look like in the year 2030, when today's nominees and today's nominee, God willing if he is healthy, will still be making judgments on that court. long after Saddam Hussein is dust, after phrases like the CIA leak are tossed into the scrap heap of historical trivia, long after President Bush and Joe Biden are gone from Washington, far into the 21st century, our newly minted Supreme Court Justice will be making critical decisions about the kind of country my children, grandchildren, and great-grandchildren will be living in. Now, I'm not going to prejudice whether I, in the end, will vote for or against Judge Roberts. He came to see me, and I told him straightforwardly what I wanted to know. I did not ask him his views at the time. I said, Judge Roberts, there are two things at stake, and I mentioned them here. How far can government intervene into the areas of personal autonomy? How far? What limits do the Constitution provide, if any? And the other side of that coin is, to what degree can the government act as a shield to prevent the powerless or the less powerful from the imposition of the heavy economic or political hand of government or corporations? And lastly, Judge, I want to know your view of stare decisis as a Supreme Court Justice. It's not the test, and I told him, whether or not he's an honorable, intelligent, well-respected man. He is. The best of my knowledge, he is. The Senate is charged first with coming to some understanding of the nominee's constitutional disposition toward the great questions of the day, and second, with expressing its judgment as to whether or not those views are acceptable at a time when a closely balanced Supreme Court is hanging in the balance. Judge Roberts finds himself the fulcrum in our deeply divided nation upon which great constitutional questions hang in the balance. He's become the embodiment of the people's hopes and fears about where the Constitution heads in the future. For the American people fully understand, we vastly underestimate their soundness of their judgment. They fully understand that the decisions he will make will affect the very way they can live their lives for a long time to come. It's an unenviable position and an enormous responsibility for Judge Roberts. I will examine if, in my opinion, he's prepared to protect the personal autonomy and the ability of the government to act as a shield to protect those with less power from the abuse of powerful interest. And the critical determination, as I said, will be his judgment on stare decisis, critical for me. These questions will be determined, will determine how I will vote. For I want to make it clear to you, and especially you students here, after you go through great constitutional law scholars under which you study, and they talk to you about the way in which the founders may or may not have intended the advice and consent clause to work, I suggest you do what I suggest my students do. Take off your legal scholarship hat, stand back and ask yourself the rhetorical question. Can you imagine on that hot, steamy summer of the founders sitting on the second floor so no one could hear what they were doing? Can you imagine them saying, by the way, we're going to have 3 co-equal branches of the government. 2 of them will be able to be scrutinized by the American people, and the presumption will be that they're not entitled to the office unless the majority of the people conclude they should be, hold the office. But the 3rd branch, all we want to know is, are they honorable, decent, and straightforward men? As my little granddaughter says, Pop, give me a break. Thank you very much, ladies and gentlemen, for listening.